school districts that are trying to transition children behind their parents' back. Washington Post reporter today who was receiving leaked information from the Department of War. Girls and young women like Riley Gaines who had their dreams shattered by boys who are not very good athletes. Hundreds of thousands of dead people on the voter roll. This isn't the Soviet Union. We don't arrest people and then ask questions later. Secretaries of state who've been fakely out there campaigning about election integrity, and yet when the federal government steps up and offers to help, they refuse to cooperate with us. Hundreds or thousands of non-citizens on the voter rolls.
I am so honored to have my dear friend Harmeet Dhillon, who is the Assistant Attorney General for the Civil Rights Division with the Department of Justice. Welcome to Reliably Republican, Harmeet.
Thanks for having me, Casey.
It's amazing. I tease because I'm like, it's hard to keep up with President Trump, but I've seen the amount of activity coming out of your office. And I think you are a pretty close second to the president with the amount of things you have going on. And I know I saw just earlier that hot off the presses today, you got a favorable opinion in an amicus brief that you filed regarding mail-in ballots and how federal candidates can challenge those procedures. Can you tell us a little bit about this breaking news?
Well, absolutely. So this was an important ruling out of the Supreme Court. And as those who follow election litigation may recall, after the 2020 election, there were a number of times that the lower courts and the Supreme Court turned away cases on the theory that a particular party didn't have standing. So in this case, it's a member of Congress, and it was often held that candidates didn't have standing to challenge the election procedures of a state. Now, sometimes political parties could challenge them, or the state itself could challenge them, the Department of Justice, but not the people most actively affected by flawed procedures and failure to follow them. And so this important ruling says it doesn't go to the merits of whether the mail-in balloting that is challenged is lawful or not, but it does say that the candidate can challenge it. And this is going to really affect election litigation nationally for federal elections. And it's a very positive and important ruling. At the Solicitor General's office, they worked with the Civil Rights Division on briefing this at the Supreme Court, and they did a great job arguing it as well.
So I know that you have fought most of your professional life for fair and free elections, and I know that you have been working with states trying to get their voter rolls. And can you tell us a little bit about your work there and where everything stands with those efforts?
Sure. I'll have to try to keep the numbers straight in my head. I may get one or two numbers wrong, but we have gone after the voting rolls in all of the states and District of Columbia, and we are looking at the data under the Help America Vote Act and under the Attorney General's authority under the Civil Rights Act of 1960. She has a right to request these records, and we have a right and a duty at the DOJ to make sure that states are complying with our federal election laws, including maintaining clean voter rolls. And what we were finding is that many of them aren't. And this is consistent with some of the news stories you've seen out there. There have been reliable reports of hundreds or thousands of non-citizens on the voter rolls, and some of them have definitely voted. And we have hundreds of thousands of dead people on the voter rolls, or people who are registered in more than one jurisdiction. This violates the equal protection and the fairness rights of all American citizens who vote, each of whom are entitled to have their votes cast only one time, and their votes counted only with other American citizens who are entitled to vote. And so I think it's very interesting that a number of states, including many Republican-led states, are refusing to provide us with this information. They're citing state privacy laws and other nonsensical claims that certainly in no way impede our ability as a federal government with federal supremacy to enforce our federal laws regarding federal elections. Some of the arguments we've heard, Casey, include, why are you asking for the Social Security number? That's top secret information. The federal government issues the Social Security numbers. It is not top secret information from us. And we are going to either get these voluntarily or sue. So now we've got about a dozen or 13 states that are either in the process of complying with us or they've already complied with us. We have a few more who are considering what they're going to do. There may be pending litigation already to stop them from giving us the voter rolls. And there are a few that I'm planning to sue in the immediate future. And we're in litigation right now with 23 states and the District of Columbia to get their voter rolls. These states include notoriously Georgia, which has completely refused to cooperate with us. And it's one of those jurisdictions where, they have some dubious practices and some dubious record keeping. We just saw reports, KC, about Michigan having a number of people on their voter rolls who are not lawful. And we have a couple of different inquiries out to Minnesota, including litigation, regarding their dubious practice of allowing people to vouch for each other instead of proving their residency with some kind of government ID or even a mortgage statement or utility statement. So we're not going to rest here at the Department of Justice Civil Rights Division until we have fully litigated this issue, and ideally that we have gotten all the voter rolls, have helped states clean up the voter rolls, and have set a standard that it's not acceptable to have loose and inaccurate voter rolls throughout the United States as we currently do.
I read somewhere, or I may have heard you say, I'm not real sure, but is this the first time the United States Department of Justice has actually done this in the states to clean up the voter rolls?
That's right, because I came into office and I thought, okay, now I finally have the power of the federal government. I've been doing this from the other side. So let me get like what a lawyer does. They join a new law firm or what have you. They say, who's got the form bank? Who's got some examples of this being done before? So I don't have to reinvent the wheel. So I said, okay, where's the form for Help America Vote Act or requesting voter data litigation? And there wasn't any. So we came up with a template. We tried a couple of different things, and we are running with it. And we even had success in court last week. We had, within hours, like less than 2 days after filing our lawsuit in Connecticut, a federal judge issued an order to show cause against the state, putting the burden on the state as to why they shouldn't be ordered by the federal court to turn over the voter rolls as soon as possible, because the judge looked at it and I think he agreed on its face that we were presumptively entitled to this data. So that really flips the tables, and we've filed that with a number of courts. And so I think we're hoping to turn the tide here and stop having to waste so much of our attorneys' time in litigation where states have a duty to hand the stuff over. And I'm kind of surprised by the number of secretaries of state who've been fakely out there campaigning about election integrity, and yet when the federal government steps up and offers to help, they refuse to cooperate with us. This is not going to fly, so we're extremely aggressive on this.
It seems bizarre to me that secretaries of state wouldn't want this. This is their job. And, I'm just thankful that you're there doing this work, because it's just so important to making sure that we're protecting the vote. And I know that you have just been so busy with all the activities there. But one thing I did want to ask you about is it seems like things are just happening like crazy this week. And I know that you all filed briefs with the 2 cases with protecting girls' sports. And I know you sat through those hearings. And I just wanted to get commentary, since you were actually there in the room and heard the arguments. Wanted to just get your thoughts on that.
Well, thank you for asking. As you know, Casey, it's been a passion of mine to protect the rights of women in every context, and I've been going to court for years now on transgender issues to protect girls and women against unscrupulous doctors, medical practitioners, school districts that are trying to transition children behind their parents' backs, and other issues like this. There's just a whole host of ridiculous things happening. One of the things happening is we're seeing girls and young women like Riley Gaines who have their dreams shattered by boys who are not very good athletes when they're identifying as boys. Suddenly, because of their physical attributes, testosterone, size of their muscles, etc., having gone through puberty, are able to absolutely crush any woman, even the world's best athletic woman that they compete against. This is totally unfair. It violates the principles of the important federal law, more than 50 years old now, Title IX, that protects and advances the rights of women in education, including in the sports arena. And, women are actually getting injured in wrestling and volleyball and contact sports. In track and field sports, which these 2 cases involve, they're simply getting beaten at the podium. And so the first of these 2 cases, it was a very lengthy argument. It's called Hecox, by the name of the plaintiff, Lindsay Hecox. Lindsay Hecox is a boy, a young man, now in Boise in college, and was identifying as a woman for track and field and was taking hormones, and not just I don't think it was just fake for the sport. This person was actually taking estrogen and trying to change their circulating testosterone. And the argument was that because this person doesn't have the attributes of a male because of the testosterone suppression, they should be allowed to compete in girls' sports. And this would have violated an Idaho state law that reserves girls' sports for women only. And so the ACLU went to court and challenged this law. And this is what is in front of the court. And the court is grappling in this issue with a number of complex legal concepts, including whether this case is moot, because Lindsay Hecox has now said they don't intend to continue any sports activity in the future. This is a tactic by the American Civil Liberties Union, I believe, legal tactic to try to get rid of this case when the Supreme Court took it up, because it's a bad case for them, I think, factually. And so that's something the court's going to have to get to deal with. The court's also going to have to deal with a sort of arcane concept of when you have an as-applied challenge to a law that is governed by an intermediate scrutiny analysis under equal protection jurisprudence, whether that kind of as-applied challenge effectively eviscerates that standard and converts it into a strict scrutiny standard. I know that's a lot of legal gobbledygook, but put very simply, the plaintiff isn't challenging the constitutionality of the law. The plaintiff is saying, in most cases, that works for most people, that only women should be in women's sports. But what they're saying is it's really unfair as to me. So I want you to make a case-by-case analysis with a very strict standard as to why I should be allowed to participate, even though this law is fine for everybody else. That's not appropriate in intermediate scrutiny analysis, which is how sex segregated laws are generally judged under Supreme Court jurisprudence. So that's a very interesting issue. But, I was sitting next to my colleague, Jesus, my principal deputy. We co-authored the brief in this case with the Solicitor General's office, which argued the United States position very, very well in this case. And we kept looking at each other and raising our eyebrows at some of the questions that we were hearing, particularly from Judge Ketanji Brown Jackson, and there was some questions from Justice Sotomayor, Justice Jackson, I should say. And it was interesting to hear the question being posed and the acrobatics about, who's a woman and why shouldn't we allow different situations and different standards for different people, which is not how laws generally work. So that was very interesting. Also interesting is, even though, this issue is sort of stereotyped as a left-right issue, there was a challenging case in Supreme Court jurisprudence which got a majority of the conservative justices, the Bostock decision, about who can use the bathroom in a workplace. And the Bostock decision says that workplaces are required to allow people who are identifying as the opposite gender into the bathroom. And conservative justices warned at that time that this would lead to a slippery slope, and it would be applied in the educational context, and that is exactly what happened in the Hecox case and in the Ninth Circuit. And so now I think justices understand how ludicrous it is, most of them, that we're even having this conversation about whether girls should hand their trophies over to boys. And now they're having to grapple with some of their bad law in the past. And so I think that's going to be interesting to see to what extent Bostock is limited or otherwise. Now, the second case involved Title IX, not a constitutional challenge. And Title IX, as I mentioned, is the law that protects and advances the rights of women in education, including in sports. And that is a West Virginia law, which similarly provided that first of all, educational sports has to be, this is in the K through 12 setting, either male, female, or co-ed. And if it's female, only women can participate in that. And so a similar type of a challenge was made. Again, ACLU lawyers were there to challenge this case. In this case, this person had not said they're going to stop doing sports. And this was, I think, a shot put and a track athlete. And again, the court discussed and looked at the legislative record here, which talks about injuries to women, the purposes of Title IX, and why women need to be protected and have the opportunity to thrive in a sports setting on their own. And I think there was a lively discussion there as well with, again, some eye-raising questions from some justices who don't seem to understand gender, sex differences and characteristics. And I found one of the most interesting questions that some of the devil's advocate questions from Justice Thomas, Justice Alito, they were asking a very good devil's advocate question, which is, well, what if I'm not taking estrogen? What if I'm just a bad athlete as a dude? And what if therefore I'd like a special exception made for me to be able to compete against girls so that I can win? Whereas if I were competing against boys, I couldn't do that. Would that be okay? And I think the lawyers who are representing the plaintiffs in this case had a hard time with that because they're advocating for a case-by-case analysis on the basis of fairness. But, where do you draw the line there? And so I think the court's going to have to grapple with, is someone identifying as the opposite sex really a protected category subject to strict scrutiny, or what? And in a couple of recent cases, the court has answered that question in the negative. And one of those is from 2025, the Scrimeti decision out of Tennessee. And so I think that's the direction this court is trending, is to say that trans identification is not an inherent characteristic. It is not something that's going to be entitled to strict scrutiny. And so we'll see how it goes. I think the court's going to have some interesting questions to grapple with. That was a very long answer to your question. Sorry.
Oh, no, you're totally fine. I enjoy listening to you talk and educating me on all of the issues. And, I've seen and listened to some of the audio from yesterday, and you mentioned some of the interesting questions. And I about fell out of my chair when I heard them ask, basically define a woman for us. And they absolutely refused to. Counsel refused to define and said that's not what we're arguing here, or something to that nature. And it was very shocking to me to see that answer. And of course, that's what's getting a lot of the audio bites today on what happened yesterday. And so it sounds like, based on what you just said, it looked like it was possibly a very good day for protecting girls' sports. And I'm just truly grateful for all the work that you've done there. And I know, Harmeet, that you're very busy. I have one final question for you, and I think this is really going to be an easy one. Are you sick of winning yet?
It's been a great first year almost here in the Department of Justice. I love working with AG Bondi. I had a lengthy couple of meetings with her earlier today, and the number of things that lady has to keep straight in her head. I mean, I only have to deal with civil rights, which is 12 or so different subject matters and hundreds of lawyers, and she also deals with national security and the border and arresting leakers. So we had a raid on a Washington Post reporter today who was receiving leaked information from the Department of War. It's a huge job, and people don't understand that. I see a lot of criticism online. That can be a little bit dispiriting. People think, you change power and you come in and you start arresting people. This isn't the Soviet Union. We don't arrest people and then ask questions later. In the United States, we build cases. You have to have personnel to do that. You have to get your staff confirmed. One of my colleagues who heads one of the most important sections of the Department of Justice, the criminal division nationally, was just confirmed in December because, apparently the Senate hasn't considered it to be a high priority to confirm the president's people. So that really limits our ability to do our jobs. But in this 9+ months that I've been in office here, I was sworn in, I think, April 5th last year. It's been an incredible job, the honor of a lifetime. We've already made some great law, a lot more in the pipeline. And it's a team of happy warriors over here. And we just every day open up our phones in the morning and start cranking away and then get to work and crank some more. And sometimes we're working late into the night until midnight to file briefs, confer with one another, share leads, get in touch with members of the cabinet. I do that frequently and answer questions and help them with certain legal issues and troubleshoot and share. I think this is one of the best Republican administrations in American history, and I'm so proud to support this president and the Attorney General. So thank you for asking and thank you for having me.
Yeah, thank you so much, Harmeet, and thank you for everything that you're doing. And I think you're being generous by saying you work till midnight. I don't think you ever stop working. I think you probably work in your sleep. So thank you for everything that you're doing. I wish I had a whole hour to ask you questions, but I know you're very busy, and just keep doing what you're doing. And please know that there are a lot of us out here very grateful for everything that you are doing to contribute to our country. So thank you so much.
Thank you, Casey.
I want to thank my good friend Harmeet Dhillon, the Assistant Attorney General for Civil Rights in the Department of Justice, for being on the program today. We had a great discussion about elections and election integrity and protecting the vote. And we also talked about protecting girls' sports. So I hope you all enjoy it. And if you want to see more of this, please subscribe to my channel.